Kumar Mishra ji, Chairperson of the Bar Council of India, Shri Apurva Kumar Sharma, Shri S. Prabhakaran, all the distinguished senior members of the Bar Council of India and of all the state bar councils, the High Court bar associations who have graced this occasion, Senior Member of Parliament, Mr. P. Wilson, all the members of the family who are here, particularly my very respected mother-in-law, my very gracious wife, my sister, brother-in-law, friends, my sisters-in-law who have traveled far and wide from Canada and Bangalore. Very dear friends Rebecca and Annie who are also traveling to be here. And friends, I must express my gratitude to all the members of the bar for having organized this beautiful function and wearing all these turbans with multi hues, different colors, different embroidery, different tapestry, different texture, the texture of the scarves, the colors of the scarves, the colors of the paintings which were presented to me, really symbolizes the vast diversity of the country. It reflects what we are as a people. But above all, it reminds us that through all these beautiful colors which define our clothes, our festivals, our religions, our ways of thinking, we are yet one nation. And we are welded together. We are welded together as one nation. Years and years ago, when the Constitution was drafted, a thought was expressed in the Constituent Assembly. How can a nation as diverse stay together? And over 7 decades since independence, after 75 years, we have demonstrated to the world that the reason why we are so tightly knit together in a bond of citizenship, in a bond of nationhood, is because we deeply understand and respect each other, our humanity, and what better place to respect than the members of the bar. Your chairperson is Manan Kumar Mishra ji. मनन को हम चिंतन भी कहलाते हैं, तो आज समय ऐसा है कि थोड़ा सा कुछ हम मनन चिंतन भी करें अपने इस व्यवसाय पे, on this institution of which we are proud members. I've been most honored to be compared with the youthful looks of the distinguished law minister. I can only say that he is genuinely young. I am only an imposter. While doing a quick Google search a short while ago, I realized that I was 12 years and 8 days old when the law minister was born. So that would justify my saying that I'm really an imposter. He belongs to the category of the young. My early years in the legal profession were years of learning, of imbibing, of sharing small luxuries, small pleasures, like the bar canteen where we would discuss law, we would discuss all the social issues of the day, and we would think that the weight of the nation was on our shoulders. And we believed that we had ideas to every social evil which plagues our society. On one wintry morning in the law school, I was a student of the Campus Law Center here in Delhi. One of my friends walked up to me over a cup of tea and said in Hindi, "Ab tu karega kya? What will you do in life?" So I said, I will do exactly what all of us are here to do, which is to study law and become lawyers. But then he said, "Par zindagi kaise guzarega? How will you make your livelihood?" So I said, I was a little nonplussed, and I said that, well, by practicing law. But then he said that, देख, मैं आपको कुछ सच्चाई सुनाना चाहता हूँ कि इस प्रोफेशन में आपको जीना है तो और कुछ भी थोड़ा सा अपना ले. तो मैंने कहा, तो क्या अपना लें? What should I do? So he says, why don't you get a gas agency or a retail oil dealership? So you can tell the world that you are a lawyer, but you will have sufficient means to sustain yourselves. And I said to myself, that thought has never left me. Because in so many ways it reflects the truth about our profession. That while you have at the tip of the profession top-notch lawyers in the Supreme Court who would have, say, 7 or 8 screens open before them when the video conferencing hearings were going on so that they could flip from court to court at the flip of a mouse. Yet you have lawyers, when the court was shut and the registrar's court was not functioning during the COVID times, they were virtually living from hand to mouth. One of the first things that the Supreme Court Bar Association president told us was, sir, when you reopen the court, please get the registrar's court going. Now the registrar's court deals with very small procedural issues, substitution of legal heirs, placing a matter before the chamber court, all the small things for which juniors run to that court. But he said that is what sustains the junior's life and livelihood, because that's when a junior will get 800,000 rupees to appear. And at the end of the month, over from the High Court into my office, but it was all of 180 square feet, which was sufficient to sustain the kitchen, the home, the hearth, and the family. As a young law student, when we went to the Campus Law Center, we would take the DTC bus. I still remember the bus route numbers, which was 210, 220, or 240. It took the ring road. If it was very crowded, you took a 101, which went to Regal and which went through Old Delhi. It took a longer time. And again, as young students of law, we would use those conversations in these buses to talk about law, to talk about what we are reading, or just plain friendship and camaraderie. And that sense of friendship and camaraderie is what sustains our profession. All of us in the profession, and when I say all of us, I don't mean the judges, because by training, we do not have a political ideology. We decide cases on the basis of the law. But all of us as lawyers, we have our own ideologies, we have our own predilections, we have our own social backgrounds. But the beauty of the legal profession is that when we wear that black coat, a white shirt and black trouser, and wear that gown over us, it kind of masks everything that lies underneath. And it is a reminder to us that irrespective of what we profess or believe, we are all involved in one common mission, which is the mission to do justice to common citizens. I did my BA in Economics Honours from St. Stephen's College, an elite institution of the university, of which I am deeply proud even today. Some of the finest minds in the country, which are laying down policy even today, were batchmates of mine, and I look up to them even now. But that journey from St. Stephen's College to the Campus Law Center was a journey of a different universe. Because when we became students of law, you had students from all different backgrounds. Not students who are necessarily academically the brightest students in the nation, but students who had an earthy understanding of life, farmers' children, children who would be the first generation of lawyers in their families, who taught us about the reality of India and from whom we learned the reality of India. An independent bar is inextricably linked with the independence of the judiciary. The reason for that is that as judges, we have no personal defense or a platform to defend ourselves. I always welcome critiques of judgments, and naturally so, because the areas of law which we write on, particularly as judges of superior courts, like the High Courts and now the Supreme Court, many of these areas of law do not speak of one solution. Even when we deliver a judgment or write something, you go back and ask yourself, is this the best solution which I have found? You would be a hypocrite if you didn't question yourself. So because we write on areas which are so complex, socially complex, there are bound to be differences of opinion, and any critique of the court is welcome. But ultimately, our real defense to our own independence as judges comes from the bar. And it is a bar which has stood up for what is right in the judiciary. I was part of a bar which passed a resolution against 4 judges of the Bombay High Court whom we felt were not exactly true to their oath of loyalty to the Constitution, to do their duties without fear or favor, affection or ill will. And we passed a resolution that we will cease to appear before their judges. But that same bar has stood for the independence of judges when they have been wronged. So we are, in that sense, when we are members of the bar, we are the conscience keepers of the nation's judiciary, conscience keepers of the quest for justice to common citizens. The district judiciary, whom so many of you represent as bar councillors, is the first point of interface with our common citizens. When a common citizen has a problem, say an arrest or a threat of arrest, the first point of contact is that when you apply under section 438 before the court of competent jurisdiction in the district judiciary and seek anticipatory bail, at the stage of remand, that is the point where the citizen has the first interface with the system of administering justice in our country, not with the high courts, not with the Supreme Court, but with the district judiciary. Our district judiciary is really confronted with a paucity of infrastructure. The central government has a large number of schemes, but the monies which are meant for the district judiciary have to devolve on the district judiciary for improving the infrastructure. Just the other day, when the Supreme Court Bar Association felicitated me, I pointed out the reality of the district judiciary as it functions. I pointed out that when I was the administrative judge of the district of Kolhapur in Maharashtra, there was no toilet for women judges. And the women judges told us, as administrative judges, that we go to work at 8:30 in the morning and our first interface with the toilet is at 6 o'clock in the evening when we return home. We feel extremely awkward to go to the public toilet for women because we have to cross the under-trials who are sitting just outside the toilet, and I'm then sitting in the court. Just the other day, I read a report about the fact that there was no toilet for women in Hathras. Now, this is not just a problem of funds, it's also a question of commitment, of us to ensure that funds which are made available are truly employed for the purpose for which they are intended. But yet our district judiciary soldiers on. As we saw, our district judiciary soldiered on during the times of the COVID-19 pandemic. Our lawyers suffered very grave distress during the course of the COVID-19 pandemic. Just as society suffered distress. Yet our bar associations tried to keep the flag burning, the torchlight burning, and the flag flying high by providing for assistance to lawyers. So this was a great mission which the Bar Council of India, our High Court Bar Associations, the district bar associations did to protect young lawyers, middle-aged lawyers who live from month to month, who have no resources to fall back upon if there is a point of distress. Much has to be still done for improving the service conditions of our district judiciary. But above all, we have to bring to our district judiciary a sense of dignity, a sense of self-worth, a sense of confidence in their own respectability, which is why I always say that our district judiciary is not a subordinate judiciary. It is really the district judiciary which is equally important in the affairs of the nation's judiciary as in the High Court or the Supreme Court. The Supreme Court may lay down these big ticket judgments, as they called, important issues which are decided by the Supreme Court. But the district judiciary in those small cases, they define the peace, the happiness, tranquility, and faith of common citizens. The way we look at the district judiciary affects deeply our own personal liberty as citizens. If district judges do not have the confidence in their own abilities, in their own respect, in the hierarchical system, how would you expect a district judge to grant bail in an important case? It is very easy to have a general mantra in a criminal case. The offense is a heinous offense, therefore there shall be no bail. This is an offense involving murder. This is an offense involving rape. So there shall be no bail. But we know as judges, and you know as lawyers, that even within that category of cases where the offense is heinous, there may be a tendency to rope in somebody who is not exactly guilty. We also know that sometimes informants tend to over-exaggerate a first information report. Now, how do you sift those who may be guilty from those who may possibly not be guilty? That is the art of the district judge himself, and that is what the lawyers have to point out to the district judiciary. And it is when we do this common mission, the higher courts are getting flooded with bail applications. I've just taken a decision as Chief Justice of India that there are 2,000 bail applications pending in the Supreme Court, 3,000 transfer petitions pending in the Supreme Court, 5,000 out of the total pendency. So we decided at the full court meeting the other day that all benches of the Supreme Court will take 10 bail applications every single day. The idea being that we have 13 benches today, so 130 bail applications will be disposed of, 650 at the end of 1 week. Hopefully at the end of 4 weeks we would have, of course there will be fresh bail applications. But this turnover has to constantly be maintained of matters which are filed and matters which are disposed of. But the reason why the higher judiciary is getting flooded with bail applications is because of the reluctance of the grassroots to grant bail. And why are judges at the grassroots reluctant to grant bail? Not because they don't have the ability, not because the judges at the grassroots don't understand the crime. They probably understand the crime better than many of the higher court judges because they know what crime is at the grassroots in the districts. But there is a sense of fear that if I grant bail, will somebody target me tomorrow on the ground that I granted bail in a heinous case? This sense of fear, nobody talks about, but which we must confront. Because unless we do that, we are going to render our district courts toothless and our higher courts dysfunctional. One of your members from Varanasi just gave me a very beautiful statement written in Hindi this evening, that why is the High Court of Judicature at Allahabad flooded with bail applications? Should these applications not be considered by the district judiciary? But the reason for it is the culture of distrust which we have generated amongst ourselves. Why should we distrust any person who grants relief to a citizen? If you commit an error, surely that error is amenable to correction. And it's not that we in the Supreme Court never commit errors. As they always say, the Supreme Court is not final because it is right, but it is right because it is final. So the process of dispensing justice is so intrinsically human that we have to learn to trust our district judiciary. Because it is when we learn to trust our district judiciary that we will truly answer the needs of our common citizens who seek access to justice. As chairperson of the E-Committee, I've been greatly benefited by the collaboration with the Department of Justice, which the Law Minister oversees as both Minister for Law and the Justice Wings. Now, there is a technological divide in our country, which Manan Kumarji referred to a short while ago. But when we employ technology, let me make it very clear that the purpose